Welcome to The Explainer. If you are deep in prep for the Queensland bar exam, you absolutely know that the Evidence Act is non-negotiable. So today, we're going to dive straight into Part 6, and my goal is to break this down from dense legislation into a really practical toolkit you can actually use.
So, picture this. It's the scenario that is, every advocate's nightmare. Your star witness, the one whose statements your whole case is built on, suddenly gets a bout of amnesia. Or worse, they tell a completely different story. Well, this is exactly where Part 6 of the Evidence Act comes into play. It's not just a bunch of rules, it's your arsenal. It's what you reach for in these exact moments. Okay, first things first. You can't use a document if you can't even get it into evidence, right? So the very first tool in our kit is all about authentication. It's about how you prove that a statement in a document is what you claim it is, without getting completely bogged down in those ancient common law rules.
And this is where the Act just makes life so much easier. Under the old common law, you have this original document rule, and frankly, it was a headache. You had to produce the actual, physical, original document. If you couldn't find it, well, you were in for a real fight trying to prove it was lost or destroyed. The Act just sweeps all that away. Now, a verified copy is totally fine. You don't have to explain where the original is. It's a massive, massive shortcut.
So, Section 97, this is your new best friend for authentication. And I love this little detail from the commentary. The section's official heading is actually described as inept. It's just a great reminder to always look past the titles and get to the substance. And the substance here is super simple. You can prove a statement just by producing the document or an authenticated copy. It's efficient and it's powerful.
Okay, so you got your evidence in. The game is not over, not by a long shot. You have to anticipate what your opponent is going to do next. And their most powerful counterattack in Part 6 is found in Section 98. That's the judge's broad discretion to just exclude your evidence.
And here it is. Even if you have ticked every single box, followed all the rules under the Act, a judge can still look at the statement and decide to reject it. The magic words are, if it's inexpedient in the interests of justice. Now, this is a huge safety valve in the system, and you need to be ready to argue why admitting your evidence actually serves justice instead of getting in its way.
So, when does this power actually come up? The commentary gives us some really clear hints. The classic one is that the evidence is more prejudicial than it is probative, meaning it risks unfairly harming a party more than it actually helps get to the truth. Other reasons? Well, it might be oppressive if your opponent can't cross-examine the person who made the statement. Or, if the statement just doesn't have much weight and looks like it was created just to prop up a weak case.
But this quote illustrates the balancing act perfectly. Even though the judge has this power, the Court of Appeal has basically warned them, hey, don't use this to undermine the entire purpose of Part 6, which, remember, is to make evidence more accessible. Justice Pincus is essentially saying judges shouldn't just assume this kind of evidence is unfair from the get-go. The discretion is there as a shield, not as a sword to just strike down the legislation.
All right, your evidence is in. It even survived a Section 98 challenge. Now what? Well, the next set of tools in our kit is all about managing how that evidence gets used in the arena, especially when you've got a jury. This is a really fascinating compromise. Section 99 deals with a very real concern, that a jury might give undue weight to a physical document they can hold and read over and over in the jury room, compared to testimony they just have to remember. So the court can admit the document, let the jury hear what it says, but then direct that the physical piece of paper be kept out of the jury room during deliberations. The evidence gets heard, but it's not overemphasized. Pretty clever.
Section 100 is really just a rule of common sense. You can't use a witness's own prior statement to back up that same witness's testimony in court. The commentary calls it self-accreditation. It basically stops a witness from saying, hey, you should believe what I'm saying now because, well, I also said it before. That doesn't add any real independent support, does it?
Okay, let's get to the big one. This is the most powerful and, to be honest, the most revolutionary tool in all of Part 6. Section 101 is an absolute game changer for advocates. It totally transforms the value of a witness's prior inconsistent statement.
This slide really shows the massive shift. At common law, if a witness said something different before trial, that statement could only be used to destroy their credibility. It created a hole in the evidence, but it couldn't fill it. Section 101 changes everything. Now that prior statement actually becomes evidence of the facts within it. It's no longer just a weapon to attack the witness. It's a tool you can use to actually prove your case.
And hey, you don't have to take my word for how weird the old rule was. Law reformers literally called it a pious fraud, and one very experienced judge just called it gobbledygook. They knew that telling a jury, okay, you can use this statement to decide the witness is a liar, but you can't use it to decide what actually happened, well, that was a distinction that was almost impossible for anyone to apply in the real world.
And this is the raw power of Section 101 in practice. Let's go all the way back to that nightmare witness from the beginning, the one who changes their story. Under the old law, they could have just torpedoed the entire prosecution. But now, because of Section 101, their original, detailed police statement can be put to the jury as real, substantive evidence of guilt. It is a total game changer.
So, as you're studying for your exams, I want you to stop thinking about these sections as just numbers. Think of them as a dynamic toolkit. Let's pull it all together into a summary you can actually remember and, more importantly, use.
Here it is, your Part 6 toolkit. Sections 92 and 97, that's your authentication shortcut to get the evidence in the door. Section 98 is your opponent's main countermove to try and get it thrown out. Section 99 is your jury management tool to control a document's impact. Section 100, that's the simple anti-correlation rule. And finally, Section 101. That's your game-changing power play to turn an inconsistent statement into substantive proof.
And that really brings us to the final, crucial thought for any aspiring barrister. Part 6 gives you these incredibly powerful statutory tools, but they always exist in this constant tension with the court's ultimate duty to ensure a fair trial. The real art of advocacy isn't just knowing the rules. It's understanding how to use these tools persuasively while always respecting that fundamental quest for justice. Mastering that balance, that's the key.